Hello friends, in the series on the income tax cases, today we will discuss a very important issue regarding the issue of notices to the non-existing entities, especially in case where there is amalgamation of certain companies into another company. It has become a settled law that the notice issued to a non-existing company is null and void. But the issue before the Honorable Delhi High Court in the present case was that in case of amalgamation, if the assessee do not intimate to the revenue specifically about the amalgamation of the company, but only realize that the income tax department was apprised of the situation that the company was going into amalgamation. So whether in that case the notice issued to a non-existing company which has been amalgamated into another company is valid or not. This issue has been taken by Honorable Delhi High Court in the case of International Hospital Ltd versus Deputy Commissioner of Income Tax, and this case is reported in 472 ITR at page number 400. The date of the judgment is 26th September 2024. In the present case, the assessment year concerned are assessment year 12-13 to 2019-20, and the notices were issued in the name of amalgamating companies, and the assessments were made, and the assessee has filed the writ petitions for all those cases where the notices have been issued in the name of amalgamating companies on the ground that the notices should be quashed solely on the ground that the notices has been issued in the name of non-existing entities. The court bifurcated these writ petitions into two sets. One set was that where the assessee has specifically intimated to the revenue that these companies have been amalgamated. For those, the court said that when the notices have been issued to a non-existing entity, then those assessment proceedings will not be validated and they will be without repair. The court said that even the section 292B, which talks about return of income etc. not to be invalid in certain cases, will also not come to the rescue of the revenue because it is not a simple venial breach and it goes to the root of the matter, because any assessment in the name of a non-existing entity is null and void. The revenue contention was that there is section 159 and 170 which comes to the rescue of the revenue. For that, it was the viewpoint of the Honorable Court that section 59 talks about the recovery of the outstanding demand from the legal year in case the tax cannot be recovered from the deceased assessee. So this is not the case because in the present case there is no recovery pending, and so section 159 is not applicable. And as far section 170 is concerned, the court said that the title of the section is that succession to a business otherwise than on death. So in the present case, because when the company is being amalgamated, the original company does not remain in existence. So this section is also not applicable because section 170 talks about of succession of the business by one person from the other person. So section 159 and 170 will not come into the rescue of the department. And for the other set of companies where the assessee was taking the plea that the revenue was apprised of the matter of the effect of the amalgamation, because the NCLT has taken the no objection from the assessing officer and the assessee has not specifically intimated to the revenue. For this, court said that simply taking the non-objection cannot be treated as an intimation to the revenue. So in those cases, the writ petitions cannot be allowed, and the court dismissed the writ petitions of the assessee. So friends, from this case it is become very clear that whenever there is some death of an assessee or any non-existence of the company because of the conversion of LLP into a private limited or vice versa, or because of amalgamation, then it is the prime duty of the assessee to immediately intimate the department if they want to avoid these type of notices. At the end of this video, once again I am repeating the name of the case. The name of the case is International Hospital Ltd versus Deputy Commissioner of Income Tax, and this case is reported in 472 ITR at page number 400, and the matter has been decided by Honorable Delhi High Court on 26th September 2024. Thank you, friends.